And then the question is, why wouldn't you do it? Well, one, they may just not want to, but from a lawyer's perspective, why wouldn't your client want to give these gifts? And here are the caveats. Number one, and that is the loss in the potential future step-up in income tax basis. As you know, death is an estate tax negative, but an income tax plus, because you get that step-up in income tax basis. And so there's that possibility you will lose that. And I say possibility because you may be able to do a transaction afterwards to undo that. So let's say you did a transfer of an asset and appreciated significantly, and then so it's a low basis asset, high value, and then you could do if it's a grantor trust, which I recommend, grantor trust, you can switch the assets, fair market value sale, and when you do that, you take the high appreciation, low basis asset back into your estate to get a step up, and you have this either cash or whatever it is, note, whatever it's going to be, into the trust. So you can do some post-gift planning down the road to get rid of that. So that's a possible step up in basis loss. Clawback, or what I call recapture, and that issue is, what if you go ahead and make this gift and they change the law again, or they don't have to change the law, they do nothing. They do nothing, where they change the law and the exemption goes from $5 million down to a lower number, and you've already gifted it. What happens? The powers that a lot of the professors out there, a lot of the articles that I've read, are pretty consistent with what happens. And that is, to the extent that you're within the $5 million exemption amount, you haven't locked in the rate. The gift tax, you don't have a taxable gift, but that clawback or recapture will end up back on the tax return, potentially. That's if this recapture clawback actually happens. If you've made a taxable gift and you've paid gift tax, you've locked in the rate. So you've locked in the rate, but it will be includable on the estate tax return. The question is, would clawback or recapture ever happen? Would you have to end up paying estate tax on a transfer that wasn't subject to gift tax? The reason it might happen is based on the current instructions on the 706 estate tax return. That's the way it works. But of course, those instructions were done before these rules came up. Anyone in Congress who's been asked, or anyone on the committees who's been asked, who has anything to do with it, says that's not what was intended. But as I say, I don't predict anymore because I think Congress is dysfunctional. So, and the IRS, we all know about the IRS. So, hopefully no one's in here from the IRS. So I would say still gift, and the clawback recapture issue is just out there. So what do you do about it? So I wouldn't stop it. I wouldn't let that stop me from making the gift. Two issues. Number one, you want to make sure there's liquidity. There's assets, there's cash, 9 months after second death, in order to actually pay a recapture clawback estate tax. Number two, that the right parties bear the burden. You don't want one party to get a big gift. Let's say your business succession plan, and one party got the business, and then the other kids get the rest of the estate. There's recapture, and all of a sudden, it's the state in general pays it, and so the kids who didn't get the gift end up paying the tax. Dysfunction city. People are not going to be happy. They're going to come after the lawyer, come after each other. It's just not going to be a good situation.
That happens?
Oh yeah, it happens. So you just want to make sure that it's not a problem. You just want to make sure you deal with it. As long as you see the issue, you can deal with it. That's what we do for a living. You need more care. Because these gifts are larger, you need to make sure they're more, unless you want to give it outright, you need to be more flexible, and you need to make sure that you're not going to harm your children or harm whoever you're giving the gifts to. So if you gave, it's kind of like lottery winners, if you give someone a lot of money now, is that going to affect their life in some negative way? You just want to make sure that you think about these issues before you give someone a very large gift, and hence why I prefer going into trust, to at least try to help deal with that. Another issue is you don't want, another attorney yesterday brought this up to me, you don't want, it's kind of like someone winning a lottery and then quitting their job. You don't want to give the child so much money that they tell their parent, I'm done and I'm off. And I'm quitting my job and I'm doing whatever and I'll see you in a few years. So there's a family dynamic issue, so you just want to make sure that you kind of see them coming and you deal with them up front.